Welcome to our comprehensive guide on winding up companies under the Companies Act 2013. In this video, we'll break down the winding up process, its legal framework, and the key roles involved. Winding up refers to the process of closing a company, settling its debts, and distributing any remaining assets. With the introduction of the Insolvency and Bankruptcy Code 2016, significant changes have been made to how companies are wound up in India. Whether you're winding up, as defined by Section 2, of the Companies Act 2013, means the process of closing a company either under this act or through liquidation under the Insolvency and Bankruptcy Code 2016. It's a legal procedure that ensures all company affairs are settled, debts are paid, and any surplus is distributed among shareholders. The process can be initiated for various reasons, such as insolvency, non-compliance, or voluntary closure. There are two primary modes of winding up a company, by the tribunal and voluntary winding up. However, with the enforcement of the Insolvency and Bankruptcy Code 2016, voluntary winding up under the Company Act has been omitted and now falls under the IBC. The focus is now on winding up by the tribunal, which is governed by Section 271 to 303 of the Companies Act 2013. This mode is typically invoked in cases of misconduct. A company may be wound up by the tribunal under several circumstances. These include passing a special resolution by the company, acting against the sovereignty and integrity of India, conducting affairs fraudulently, defaulting in filing financial statement or annual returns for 5 consecutive years, or if the tribunal deems it just unequitable. Each ground is designed to protect public interest, maintain corporate discipline, and ensure that companies operate within the legal. Let's look at a real-world example. In the case of SpiceJet Limited, v. Credit Suisse AG, the Supreme Court of India stayed the High Court's order admitting a winding up petition against SpiceJet. The dispute arose due to unpaid debt exceeding USD 24 million. SpiceJet argued that the documents relied upon were not properly stamped, but the High Court held that such a defense was not sufficient at the admission stage. The Supreme Court granted SpiceJet 3 weeks to resolve. The important case is IDBI Bank Limited, v. Official Liquidator, where the Supreme Court held that any transfer or act done in relation to company property within 6 months before the commencement of winding up is deemed a fraudulent preference and is invalid. This provision prevents companies from favoring certain creditors over others just before liquidation, ensuring equitable treatment for all stakeholders. Such legal safeguards are essential for maintaining trust in the corp. The Vardman Yarns and Threads Limited, v. Indus Garments India case, the High Court of Karnataka ordered the winding up of a company on just an equitable ground. The respondent company had acknowledged its dues but failed to pay, and its business operations had ceased. The court found it fair and reasonable to wind up the company, demonstrating how the tribunal exercises its discretion to ensure justice when companies are no longer viable or have defaulted on their obligation. Petition for winding up can be presented to the tribunal by various parties. These include the company itself, any contributory or group of contributory, the registrar, any person authorized by the central government, and in certain cases, the central or state government. This broad eligibility ensures that all stakeholders, including shareholders and regulatory authorities, have the right to initiate winding up proceedings when necessary. The process is designed to be inclusive and transparent. Contributory, typically a shareholder, can file a petition for winding up if they have held shares for at least 6 months during the 18 months before the commencement of winding up, or if shares have devolved upon them by inheritance. Even if the company has no assets or surplus for distribution, a contributory retains this right. This provision ensures that those with a financial stake in the company can seek legal recourse if the company's affairs are mismanaged or if their interest. Registrar of Companies can also present a petition for winding up, except on the ground of a special resolution. However, the registrar must obtain prior sanction from the central government before doing so. This ensures that the process is not misused and that companies are given a reasonable opportunity to present their case. The registrar's involvement adds an additional layer of oversight and regulatory control, safeguarding the interests of the public and the corporate sector. A company itself petitions for winding up, it must submit a statement of affairs in the prescribed form. This statement provides a detailed account of the company's financial position, assets, liability, and other relevant information. The tribunal will only admit the petition if this statement is provided, ensuring transparency and enabling the tribunal to make informed decisions. This requirement helps prevent frivolous petitions and ensures that the process is based on accurate information. On receiving a winding up petition, the tribunal has several options. It can dismiss the petition, make interim orders, appoint a provisional liquidator, order the winding up of the company, or pass any other order it deems fit. The tribunal must make its decision within 90 days of the petition's presentation. This structured approach ensures timely resolution and provides flexibility for the tribunal to address unique circumstances in each case. If a petition is filed by someone other than the company, the tribunal may order the company to file its objection and a statement of affairs within 30 days. This period can be extended by another 30 days in special circumstances. Failure to file the statement can result in forfeiture of the right to oppose the petition and penalty for responsible director or officer. This requirement ensures that the tribunal has all necessary information to make a fair decision. A winding up order is passed. The tribunal appoints a company liquidator, who may be an official liquidator or an insolvency professional registered under the Insolvency and Bankruptcy Code. The liquidator's role is to manage the company's affairs, realize assets, and distribute proceeds. The tribunal specifies the terms, conditions, and fees based on the liquidator's experience and the company's size. This ensures that the winding up process is handled by qualified professionals. Tribunal can remove a provisional or company liquidator for reasons such as misconduct, fraud, professional incompetence, inability to act, or conflict of interest. If a liquidator is removed, resigns, or passes away, the tribunal can transfer their duties to another qualified liquidator. This mechanism ensures accountability and continuity in the winding up process, protecting the interests of creditors, contributory, and other stakeholders. So winding up or liquidator appointment order is made, the tribunal must inform the liquidator and registrar within 7 days. The registrar then updates company records and notifies the official gazette. For listed company, the registrar also informs the relevant stock exchanges. This process ensures transparency and public awareness, allowing creditors and investors to take appropriate action based on the company's status. Within 3 weeks of a winding up order, the company liquidator must apply for the constitution of a winding up committee. This committee assists and monitors the liquidation process, ensuring that assets are taken over, claims are settled, and distributions are made efficiently. The committee typically includes the official liquidator, a nominee of secured creditors, and a professional appointed by the tribunal. Regular reports and meeting minutes are submitted to the tribunal for oversight. Winding up order operates in favor of all creditors and contributory, as if it were made on their joint petition. This ensures that the interests of all stakeholders are considered and that the process is conducted fairly. The order also serves as notice of discharge to company officers and employees unless the business continues. This legal effect marks the formal commencement of the company's closure and asset realization. Once a winding up order is passed or a provisional liquidator is appointed, no new suits or legal proceedings can be initiated or continued against the company without the tribunal's permission. However, this restriction does not apply to appeals pending before the Supreme Court or High Courts. This provision protects the company's assets from being dissipated through multiple legal actions and ensures orderly settlement of claim. Tribunal has wide jurisdiction over all matters related to the company's winding up. This includes suits, claims, applications, and questions of law or fact, whether arising before or after the winding up order. The tribunal's comprehensive authority ensures that all issues are resolved in a single forum, promoting efficiency and consistency in the winding up process. Within 60 days of appointment, the company liquidator must submit a detailed report to the tribunal. This report includes information about the company's assets, liabilities, creditors, contributory, contracts, legal cases, and any suspected fraud. The report helps the tribunal assess the company's financial position and decide on further action, such as asset sale or investigation. Stakeholders can inspect the report and take copies for prescribed fee. After reviewing the liquidator's report, the tribunal sets a time limit for completing the winding up and may order the sale of the company or its assets. If fraud is suspected, the tribunal can order an investigation and take measures to protect or enhance asset value. The tribunal's orders ensure that the winding up is conducted efficiently and that any wrongdoing is addressed appropriately. Once a winding up order is made, all company property is deemed to be in the custody of the tribunal. The liquidator must immediately take control of all assets, effects, and actionable claims. The tribunal can order any person holding company property to deliver it to the liquidator. This ensures that assets are safeguarded and available for distribution to creditors and contributory. Promoters, directors, officers, and employees must fully cooperate with the company liquidator. If anyone fails to assist, the liquidator can seek directions from the tribunal, which may order the person to comply. This cooperation is vital for the smooth conduct of the winding up process and for ensuring that all relevant information and assets are made available. After a winding up order, the tribunal settles the list of contributory, those liable to contribute to the company's assets. The tribunal distinguishes between contributories in their own right and those liable as representatives. The list determines who must pay towards the company's debt and expenses, ensuring fair distribution of liability among members. Directors or managers with unlimited liability may be required to make further contributions if necessary to satisfy the company's debts. However, if they ceased office more than a year before winding up or if the debt arose after they left, they are not liable. The tribunal decides if further contributions are needed, ensuring that those responsible for the company's affairs are held accountable when appropriate. The tribunal may appoint an advisory committee to assist the liquidator and report on specific matters. The committee can have up to 12 members, including creditors and contributories. The liquidator convenes meetings to select members, and the committee has the right to inspect company records. This structure provides additional oversight and guidance during the winding up process. Company liquidator must submit periodical reports to the tribunal, at least quarterly, detailing the progress of the winding up. The tribunal can review and modify its orders based on these reports. Regular reporting ensures transparency, accountability, and allows the tribunal to address any issues promptly. Company liquidator has broad powers, including carrying on business for beneficial winding up, selling assets, raising money, settling claims, and defending or instituting legal proceedings. The liquidator can also appoint professionals, inspect records, and apply to the tribunal for direction. All actions are subject to the tribunal's control, ensuring that the process is conducted in the best interests of stakeholders. With the tribunal's approval, the liquidator can appoint professionals such as chartered accountants, company secretary, or legal practitioners to assist in performing duty. Any appointed professional must disclose conflicts of interest. This provision ensures that the liquidation process benefits from specialized expertise and remains free from bias. Liquidator must follow directions from creditors, contributories, or the advisory committee regarding asset administration and distribution. If there is a conflict, directions from creditors or contributories override those of the advisory committee. This ensures that the wishes of those most affected by the winding up are prioritized. Liquidator must maintain proper books and accounts, recording all proceedings, receipts, and payments. These records are subject to inspection by creditors and contributories. The tribunal may order audits and require the liquidator to present accounts at least twice a year. This ensures financial transparency and accountability throughout the winding up process. Tribunal can order contributories to pay any money due to the company. In unlimited company, set-off may be allowed for independent dealing, but not for dividends or profits. Once all creditors are paid, any money due to a contributory can be set off against subsequent calls. This mechanism ensures fair settlement of debts and prevents unjust enrichment. Certain debts, such as workmen's dues and specific secured creditor claim, are paid in priority during winding up. Sections 326 and 327 outline these priorities, ensuring that employees and government dues are settled before unsecured creditors. This legal hierarchy protects vulnerable stakeholders and maintains social and economic stability. The transfer or payment made by a company within 6 months before winding up intended to prefer certain creditors can be declared invalid by the tribunal. Transfers not made in good faith or outside the ordinary course of business within 1 year before the winding up petition are also void. These provisions prevent asset stripping and ensure equitable treatment of all creditors. Liquidator can disclaim certain burdensome property or contract with the tribunal's leave, such as land with onerous covenants or unprofitable contracts. This allows the company to avoid further liability and maximizes the value of assets available for distribution. Affected parties may claim compensation as creditors in the winding up. The transfer of property, shares, or alteration in member status after the commencement of winding up is void unless the tribunal orders otherwise. Attachments, execution, or sale without tribunal leave are also void, except for government dues. These rules protect the company's assets from unauthorized depletion during winding up. Officers of a company in liquidation can face severe penalty for offenses such as non-disclosure of assets, destruction of records, fraudulent transaction, or false representation. Punishments include imprisonment and fine, ensuring that those responsible for mismanagement or fraud are held accountable. These provisions deter misconduct and uphold the integrity of the winding up process. During winding up, every business document, invoice, or letter issued by the company or liquidator must state that the company is being wound up. Failure to do so attracts fines for the company and responsible officers. This requirement ensures transparency and informs all parties dealing with the company about its status. All books and papers of the company and the liquidator serve as prima facie evidence of the truth of matters recorded. Creditors and contributories have the right to inspect these records, subject to prescribed rules. This provision supports transparency and allows stakeholders to verify the conduct of the winding up. Winding up is complete and the company is about to be dissolved. The tribunal directs how books and papers are to be disposed of. After 5 years, no responsibility attaches for missing records. The central government may prevent destruction for a specified period and allow creditors to make representation. This ensures proper record keeping and addresses future claims. The unpaid dividend or undistributed assets held by the liquidator for more than 6 months must be deposited into a special account in a scheduled bank. If unclaimed for 15 years, the money is transferred to the central government's general revenue account. Claimants can apply to the registrar for payment, ensuring that rightful owners have an opportunity to recover their due. Liquidator must file all required returns, accounts, and notices promptly. If defaults occur, the tribunal can order compliance and require the liquidator to bear costs. The tribunal may also call meetings of creditors or contributory to ascertain their wishes, ensuring that the process reflects stakeholder interest and legal requirement. Once the company's affairs are fully wound up, the liquidator applies for dissolution. The tribunal orders dissolution and the registrar records it. However, within 2 years, the tribunal can declare the dissolution void if necessary, allowing for further proceeding as if the company had not been dissolved. This flexibility addresses any unresolved issues that may arise post-dissolution. Winding up by the tribunal is deemed to commence at the time of petition presentation. For limitation purposes, the period from commencement to 1 year after the winding up order is excluded from statutory limitation periods for suits or applications by the company. This ensures that the liquidator has adequate time to pursue claims and recover assets for the benefit of creditors and contributory.